meeting back to order, and in this session we have two witnesses. And from the Canadian Bar Association we have Gordon Maynard, who is past chair, National Immigration Law Section. And from Restaurants Canada we have Joyce Reynolds, who is Executive Vice President, Government Affairs. Was there a decision on who would go first? Ms. Reynolds, I'll invite you to present first, and then Mr. Maynard, and we will then open the floor up to questions from my colleagues.
Thank you, Mr. Chairman. I appreciate the opportunity to speak today about budget implementation measures impacting the temporary foreign worker program. First, we would like to be on record as recommending that the word temporary be removed from the temporary foreign worker program so that the program actually provides a pathway to permanent residency. This program is extremely important to our members, particularly in communities in Western Canada and in pockets in other parts of the country as well, where labor shortages are acute. Having said that, you need to know that temporary foreign workers comprise a very small percentage of our almost 1.2 million Canadians and landed immigrants. Of the approximately 2% of our workforce that are TFWs, most are in Western Canada, with by far the highest number in Alberta. In Alberta's red-hot labor market, this program is critical to keeping many restaurant businesses operational. Restaurants Canada supports increased government efforts to identify foreign worker program abuses and hold accountable those employers who misuse the program. We have long supported stronger penalties and sanctions for the few who break the rules to protect the long-term integrity of the program. In a presentation I made to the Standing Committee on Citizenship and Immigration back in April 2008, I said, we were Canadian Restaurant and Food Service Association at the time, I said that we support increased monitoring and compliance mechanisms for this program and better communications between provincial governments and the federal government in this regard. I went on to say that we support restricting TFW program access to employers who repeatedly or systematically violate provincial labor standards or the terms of the TFW agreement. If there had been better monitoring for compliance and enforcement of rules, perhaps an entire industry would not have been unfairly maligned and a necessary program tarnished because of the actions of a few. Demographics tell us that the labor shortages our members are experiencing in Western Canada will spread across the country and get progressively worse as the labor force ages because our workforce is so skewed towards youth. 44% of today's food service workers are 15 to 24 years of age. But this age group has reached its demographic peak and is now in decline, with a precipitous drop of 300,000 predicted, falling from 4.6 million in 2011 to 4.3 million in 2021. So a key source of workers is declining as our need for workers balloons. Our members have responded to labor shortages by enhancing the recruitment and retention strategies and putting more emphasis on attracting and accommodating underrepresented groups, such as Aboriginals and persons with disabilities. A 2013 member survey revealed the extent employers in our industry go to hire individuals from groups underrepresented in the Canadian labor market. For example, almost 76% of respondents hire First Nation individuals, 84% hire new immigrants, 79% hire persons with disability or other abled, and 60% hire social assistant recipients. They are also increasing wages and benefits. We strongly dispute the government's assertion that wage increases in Alberta's food service sector have not kept up with the economy as a whole. This is not supported by Statistics Canada's labor force survey data. Reflecting their preference to recruit domestically, our members have moved far beyond simple job postings in their efforts to attract potential employees, including job fairs, interaction with community groups, and social agencies. And despite these best efforts, in some regions, a restaurant's only option is to turn to the foreign worker program. Restaurants Canada recently canvassed our members who make use of the foreign workers on how restrictions to the program will impact their businesses. Top-line finding is that our members expect that as new rules take effect, they will need to reduce hours of operation, curtail expansion plans, and potentially lay off Canadian workers as the contracts of current foreign workers end, and these workers are forced to return to their country of origin. The futility felt by our members on how to replace departing foreign workers was clear, with many reporting unfilled positions and burnout of their existing staff. They are also beginning the process of retrenching their businesses in terms of reduced capital expenditures and not pursuing expansion plans. We fear returning to the days of the mid-2000s when the industry in Alberta was contracting, when the demand for our services had never been higher due to a lack of workers. It is understandable that these members believe that the rule changes brought in on June 20th that severely curtail our industry's ability to access the foreign worker program are a huge overreaction by government to media reporting, innuendo, and unproven allegations, rather than government policy formulated on facts-based evidence. It is for this reason that we support the conducting of thorough investigations of all claimed employer abuses of the program. We believe the relatively few employers who abuse the program should be held to account so others are not tainted by the same brush. We do, however, have concerns about government's regulatory plans to impose consequences on employers for non-compliance that is a result of good faith errors. This is particularly important given the number of our members who say they have difficulty fully understanding the fast-evolving rules and regulations of the TFW program. 76% of respondents in our recent foreign worker survey reported they experienced difficulty receiving concise and consistent answers from Service Canada government officials in response to questions asked on how to apply and to be in compliance with the program. If an employer is able to argue that non-compliance was the inadvertent result of a non-permitted action, particularly when clear and unambiguous guidance was not available to them, we strongly advocate that no consequences should result, whether it is voluntarily disclosed or comes to the attention of government. And finally, we have concerns about giving department officials blanket authority to publicly expose an employer without due cause or natural justice. We want to ensure that there is an oversight and appeals process in place. With regard to the privilege fee, the TFW program is already costly, and this fee will make it more so. When the $275 LMO user fee was imposed, our members were prepared to help bear the cost of the program, particularly because they were led to believe it would lead to improvements that would speed the application and approvals process. Instead, they paid tens of thousands of dollars in fees for a more cumbersome process that often did not result in a positive application or a work permit. The fee more than tripled in June, putting the program out of reach for many operators. To make matters worse, the application process is slower still. Instead of implementing an additional fee, Restaurants Canada recommends that applicants whose LMIA has been rejected be provided with a partial refund of the fee, since the portion of the fee allocated for compliance and enforcement would no longer be applicable. To conclude, at Restaurants Canada, we appreciate the need to protect the integrity of the program and to ensure the intent of the program, Hire Canadians First, is respected by all users of the program. We are supportive of measures that will ensure that appropriate monitoring and compliance mechanisms are in place and that abusers of the program are denied access. The foreign worker program is critical to the continued viable operation of Canada's restaurant industry, particularly in those regions of the country experiencing acute labor shortages. We are interested in working with government to put policies in place that will restore and further strengthen the efficiency, integrity, and reputation of this important program. Thank you.
Thank you. Mr. Maynard.
Thank you. First of all, thank you for those comments, Ms. Reynolds. I hope during question period we have that opportunity to speak more about your concerns in the industry. It has been a huge overreaction of the government with respect to the restaurant industry.
We'll wait. Please proceed.
My name's Gordon Maynard. I'm an immigration lawyer from Vancouver. I've been an immigration lawyer for almost 25 years. I am speaking on behalf of the Canadian Bar Association. The National Immigration Section deals as membership of lawyers across Canada, dealing solely in immigration law. The National CBA represents 37,000 lawyers, notaries, students, and teachers. And the mandate is to promote improvements in law and the administration of justice. And it's in that spirit that I bring these comments regarding Part 24 of C-43. I'm going to speak in particular about the proposal to have a new list of employers. That is, employers who have been found guilty of designated offenses under IRPA or of federal or provincial employment or recruitment law. I came early today because I wanted to listen to what the department had to say about these provisions. 3 times it was stated that employers on this list will not be able to access the foreign worker program. I was afraid that would be the consequence of this listing. You'll notice in C-43, which creates this list, this possibility of being listed, it doesn't say anything about what the consequences are. It doesn't say anything about it. The government has been very vague about what the consequences will be until those 3 statements today. In carrying out an assessment of the law and where this new list fits in, I'm afraid that we've come to the same conclusion. The purpose of the list is not to protect foreign workers. It's not to publicly give notice of employers who are breaching federal or provincial labor law. It is to set up the employers for loss of access to the program. Let me explain how that works. We already have, it was introduced last year, we already have in the regulations a list of conditions that all employers who use the foreign worker program have placed upon them. These were introduced by regulation last January. There are a number of conditions. You have to pay them according to the employment contract. You can't change the terms of employment. But one of the conditions is that during the term of employment of the foreign worker, you must comply with provincial and federal employment law and recruitment law. That's a stated condition. So that applies to all employers who use a foreign worker. If an officer in the department has reason to believe that there has been a breach of a condition, or if you have been found to have breached conditions in the past, or just on a random basis, the department can carry out an investigation of your business. That's provided for in the regulations. In that investigation, they can do entry and warrantless inspection of your business. They can compel you to produce all documents that they feel will be relevant. They can compel the business owner to attend and compel them to answer questions regarding the employment of their employees and their foreign workers. If the officer finds, as a result of that investigation, that there has been a breach of condition, then they can put you on a list. And that is the 209.91 bracket 3 regulation, 209.91 bracket 3 list. It already exists in the regulations. And if you're on that list, you are now forbidden from accessing the foreign worker program for 2 years. And that includes renewing the work permits of any foreign workers that you already have. You can imagine the consequences for an employer who is caught by this prohibition. You might be an employer in BC that has hundreds of employees, and only a small number are foreign workers. You might have project sites across the province, but a breach of a condition causes you to lose access to all of your foreign workers, and some of them might be vice presidents of your company. There might be NAFTA intercompany transferees. There might be specialized knowledge workers who have come in to fill a gap. They are now inaccessible to you. So the consequences are significant. Where does this new list fit in? This new list will list employers who have been found guilty of a provincial or federal employment law. And it's also required that the employer have had a foreign worker either in the past, currently, or they're applying to have one. You're put on this list. There's also a companion authority, and that's under regulation, or section 309 of this act, C-43, that requires the employer to provide information to the department about all foreign worker employees that they have. If the department phones up, you're required to give them the information. So now somebody in the department has a list of employers who have committed provincial offenses. They have information about them having foreign workers. They're now in a position to either suspect that they're in breach of their condition, not to comply with provincial legislation, or they have evidence that they've breached in the past. And this triggers that inspection right, the production of document rights, the compelled questioning rights, which in turn lead to a finding that you're in breach of a condition and you now have no access to the program. That is what I believe the purpose of this list is. That raises questions, as pointed out in the CBA paper. Who gets put onto this list? It says in the legislation, employers who are found guilty of an offense. What does found guilty mean? Does it mean an administrative breach? Can a provincial officer issue a ticket for an administrative breach of a safety violation on a work site?
You're going on beyond the time that we allotted, so could you please wrap up?
Certainly. With respect to the listing, we think that found guilty should only mean a judicial determination, given the consequences that will follow. We also believe that it should not be possible to be listed for any breach of any provincial legislation or any federal legislation respecting employment. There should be designated offences. The government should very carefully identify and make public which offences will justify being put on that list. Those are our recommendations there. It's a very complex area. There's much more to it than what people are saying so far. It deserves very critical examination. I'm happy to answer your questions. Thank you for your favor.
I'll now open up to questions and remind us all that this session will end no later than 12:30, and I will start with Senator Merchant to be followed by Senator Cordy.
I gather from what you said, Mr. Maynard, that you are concerned about lack of due process. Because an inspector, who is to know what triggers an inspector, to designate you in a certain way, should there be a warrant, for people to obtain, this information?
Yes.
Can people just walk in and...
Right now, the authority given to officers to enter and inspect, to demand production of documents, and to compel an employer to attend to government offices and answer questions does not require any warrant. All that is required is a reason to suspect that there may be a breach of condition. Or, if there's evidence of a past breach of condition, that allows them to move forward on it. Or, just on a random basis. It is the CBA position that this is insufficient protection, and that it is not a reasonable limit to justify those kinds of actions. And in the absence of a reasonable law providing for when these inspections can take place, there should be a requirement to get a warrant. Thank you.
I think I'll pass until
Thank you, Senator.
if I need a second question, I'll ask.
Senator Cordy.
Thank you very much. Ms. Reynolds, I was interested in your comments about the process, how long it's taking, because just at the previous panel I asked how long it takes from the time an application is made until the employer gets the authority to hire a temporary foreign worker, and I was told that unless there are extenuating circumstances that it's going to be 10 business days. And I was curious whether or not the new fee, which is, as you said, is almost 300% increase, whether or not this would make for a more streamlined process. And you're saying that, since this has been in since July, that in fact it's making the process more cumbersome than it was previous. Because if I were a business owner, an employer, I would assume that if my fees are going to be raised by 300%, that service would indeed be 300% better, or certainly a bit better.
We've heard, depending on what region, but in Alberta, where most of our members primarily make use of the temporary foreign worker, it can take months for these to be processed. And the other thing that's happened, the application form has changed 3 times since June. So you submit an application, you pay your $1,000 fee. If there's some minor problem with the application, it gets sent. Then you have to submit another one and another $1,000 fee. And then the first application, you can't even use the same application. You have to use a a different application, have to start the process all over again. It was tough enough when the fee was $275. It's just become unviable for you talked about an elderly couple who couldn't afford it. Well, for a small restaurant operator in Cold Lake, Alberta, they find the fee very, very high as well.
Because we're not talking multinational companies who can well afford $1,000. We're usually talking the small businesses, and in the case that I heard of, a caregiver of an adult son who was disabled. I'm also interested in the due process, the lists that are being made. I'm always nervous when government makes lists. Mr. Maynard, you suggested that there already is a stipulation in the laws so that if somebody breaks the agreement, that they would be not allowed to hire somebody, a temporary foreign worker, for 2 years. And yet when questions were being asked regarding this list about how long would this list be around, the answer, or certainly the indication that I received from their comments, was this was pretty open-ended. This is a list that could go on forever and ever and ever. I guess, and also related to that, there seems to me to be no due process. So if you're put on the list, there's no recourse for you, and who makes the decision that you go on the list? They're questions that I was quite concerned about.
Yep. The list that exists, you're on it for 2 years, period. And it's mandatory. If they find that the employer has breached a condition of the employment, resolve their investigation, they find this out, then they shall be put on the list. There's no discretion in it. So yes, I'm very concerned about that list, but there's nothing in the Act, nothing in the regulations, nothing in Bill C-43 that says being put on this new list causes you not to have access to foreign workers. It can only be used to get you onto the other list. And that's the only way in which it could result in you being denied access to foreign workers. So I was very concerned when I heard 3 times the department say that being on this provincial list or provincial offenders list is going to cause you not to have access to the program. That means they're going to link it to the Section 20991 list.
And there will be no due process. Ms. Reynolds, is that what you suggested for an employer?
Well, that's what the concern is. We don't know what the due process is. I should point out when we talk about that list, there are only 4 restaurants that are on that list. I mean, we've heard through the media about all kinds of allegations of abuse, and our industry has been badly tainted by that. There's 4 restaurants that are on that list.
That's
if I may, please, I'd like to clear up a concern about the 10-day answer. The government did say that there would be a 10-day processing time in the case of workers who are going to be paid high salary. And by high salary, they meant in the top 10% of the province, provincial average. So for BC, the salary is approximately $27 an hour. But that's not based on what you say you're going to pay them. It's based on what ESDC says is the prevailing wage for that position, which is always much lower. So there's only about 10 occupations out of the entire list of occupations known to Canadian mankind that would support a 10-day processing time. It's illusionary that time is existing. It doesn't exist. For the vast majority of employers, it's a 2 to 3 month process to get the LMIA. That's after you do the advertising.
right. Okay. Thank you very much.
Okay, thank you, Senator. Senator Seidman to be followed by Senator Anverga.
Thank you, Chair. Thank you very much. We spent a lot of time this morning with our former witnesses from the government and with yourselves talking about the Temporary Foreign Workers Program. But as we're aware, this piece of legislation splits the current program into 2 programs, the Temporary Foreign Workers Program and the International Mobility Program. And so we haven't talked a lot about the International Mobility Program, which is exempt from the labor market impact assessment. My understanding is that it specifically refers to foreigners entering under the free trade agreement. So do either of you have anything to say about what proportion of foreign workers, for example, would fall into this particular piece of the program? The one I refer to, that is the the International Mobility Program. Mr. Mayrand, perhaps?
Yeah. The foreign worker program now is just the LMIA workers, and they are the vast minority of foreign workers in Canada. The vast minority. Most of the other foreign workers, the vast majority of them, are now classified as international mobility program. For instance, international programs by students who, we have exchange programs and whatnot where students in Canada can go to France and students from France can come to Canada, get a 1 or 2 year work permit and work wherever they want. There's no labor market assessment done at all. They're free to do it. They far outnumber the LMIA workers that are in this country.
So do you have numbers to give us, proportions, actual proportions by any chance?
I don't want to quote from memory,
okay.
But when the government introduced the changes in June 20th of this year, they issued a document called Overhauling the Temporary Foreign Worker Program, and in the very opening segments of that document, they're well worth looking at. It gives you the figures, and it's staggering to look at those figures.
Okay, thank you. And could you give us examples, for example, of the type of work permits that would be issued under this particular piece of the program, the International Mobility Program?
Under the International Mobility Program is every kind of work permit that exists other than labor market impact assessment work permits. So this would include work permits issued under treaties like NAFTA or any of the free trade agreements that we have with Chile, Peru, etc., Colombia. It would include generally intercompany transferee work permits where companies are shifting senior managers and executives from abroad into Canada for temporary placement at companies here. Spousal work permits for skilled workers. Student work permits or student authorizations to work associated with being a student in Canada. The programs for Experience Canada programs where young people are just given a work permit to come to Canada for 1 or 2 years. All of those would be covered under IMP.
And would they represent any particular list of trades or professions or?
Well, it depends on the category. I mean, most of the students that come in are going to work at low-skilled jobs. You know, they don't come and work at professional occupations. Intercompany transferee workers have to be senior executives or senior managers or persons with specialized knowledge, so they generally are at a higher level. The NAFTA agreement includes a professionals category that brings in engineers, architects, this sort of position. All university isolates 50 positions or so. So there's a variety of positions that are involved.
Okay, thank you. That's been very helpful. Thank you very much.
If I may, this bill, the list and whatnot, that applies to all foreign workers, regardless of whether they're LMIA or IMP.
Okay, thank you.
Thank you, Senator. Senator Unverga to be followed by Senator Chaput.
Thank you, Chair, and thank you for the presentations. Actually, I was more like struck by the fact that there's some concern about the listing that's going to be in place by the government, and but somehow you mentioned that there's only four employers that are listed there. So, don't you think that the government has been really diligent in making sure that only those who are really bad will be placed on the list, or is it a lenient one, or how do you classify the government at this time? Are they really very careful in putting anybody on the blacklist here, or?
Well, from our perspective, there's been a lot of unfound allegations that have been made about our industry. I mean, there's a lot of anecdotes about, well, you know, my kid applied for a job in a restaurant and he didn't get the job, therefore that employer is overlooking Canadians. When in fact, our industry operates 16 to 24 hours a day, 7 days a week. I mean, we need people to work late night shifts. We need people to work weekend shifts. And if we have people that apply for jobs, but they're available weekdays at this time to this time. Well, sorry, that doesn't make, we're not going to hire you because we need you to work from 9 to 2. So the people don't all have the aptitude to work in the industry. So, and even if you look at
those are not on the list. The senator asked specifically with regard to numbers and the fact that there were 4 on the list. He was talking about the issue of the numbers as opposed to getting you to go into a discourse on the...
Okay, sorry, but I guess even some of the allegations that were very public, there is another employer perspective, and employers can't talk about their personnel issues in the media. And then when they actually do the investigations, they find that what has been alleged is maybe not necessarily the actual case. So, because there were an awful lot of allegations that were made about our industry. So I guess, I don't know the answer to your question, but my sense is that once they really start to do their in-depth investigations, they find that there's less to these stories than that were covered in the media.
So, from your perspective, Mr. Maynard, don't you think that the government is really diligent in making sure that only those companies that are listed there are the really different guys, the really bad guys? So there's no really concern of outright putting everybody on the list there. So
I don't think the government has pressed the gas pedal down yet. I think we haven't begun to start the process of identifying and listing employers.
I take that as speculation, but your point is...
Well, the legislation has only been in place for 1 year.
Regulations haven't been developed yet, so we're speculating considerably beyond the issue that we've got in front of us.
And another note too, I was thinking about those allegations that the industry hasn't been hiring Canadians. I mean, you said you're really hiring Canadians, but with all these advertisement and marketing that the food industry has been doing, I mean, why can't you present yourself in a different way? I mean, you've done a great job marketing your hamburger or whatever food that you have. I mean, why can't the industry adapt to this kind of marketing efforts? Hiring more people.
I would disagree with you in that I think our members have been doing an awful lot of media and marketing. They've been doing cross-country job fairs. They've been trying to attract unemployed workers from places like Ontario where there are youth looking for jobs to see if they will come out to some of these remote locations in Alberta and Saskatchewan. I would say that they've been putting a huge amount of resources. I think that what's going to give restaurants in our industry a competitive advantage in the years ahead is going to be their human resource practices, and I think that they are putting far more resources into the recruitment and retention of employees. They recognize that being able to attract and keep workers is what's going to give them the competitive advantage. So I would say there's a huge amount of efforts and resources that are going into this, but it's not as easy as it sounds to go to the street corners of Toronto and to talk an unemployed youth into moving out to some of these remote locations in Alberta. They've tried it. They've done these programs where they've tried to bring people, and one of the problems is they get some of the resource-based sectors who can always offer a higher wage. They recruit them right from behind the counters or right inside the restaurants because they have the resources to do that. So, our industry goes to the expense of, recruiting them, bringing them out to Alberta, and then they lose them once they have their fare paid out to come to Alberta to some of these other industries that we just can't compete with.
And if I may, one quick one. Actually, it's more like with these recent changes. Have you? Do you know what's the loss of the industry at all, or what are the degree of the opportunity loss for the industry that you're referring to, right?
We're in the process of trying to measure that now, and one of the challenges in trying to measure it is that these changes are progressive. So as the foreign workers permits expire and they're being sent home, businesses become increasingly more short-staffed. So it's we know that there's a lot of expansion plans that have been put on hold. We know that franchisor agreements have not been have been. They've walked away from them because without workers, they know that they can't open any more businesses. But we haven't been able to quantify exactly what the impact is going to be.
Thank you, Chair.
Mr. Maynard, you wanted to add a comment?
Yes, your comment about the progressive changes, you wait for the work permits to expire. The processes the changes put in place in June, many restaurants with foreign workers still had those workers under work permit that were valid for a year, maybe 2 years. So until those work permits expire, we won't see the impact of the changes. One of those big changes that particularly affects the restaurant industry is that the government said you're only going to be allowed 10% foreign workers in a low-skilled job, or low-paying job, and these generally count as low-paying jobs. So if you have a restaurant that employs 35 Canadians and has 6 cooks in the kitchen who are foreign cooks because you're an ethnic restaurant, you're now only allowed to have 3 cooks. And I know restaurants are telling me that they cannot operate at that level, but that won't show up until another year from now.
Thank you.
Thank you, Mr. Chair. It's a very brief question. Should there be a recourse for employees who are or will be on the list eventually? Should there be a recourse?
Absolutely. If you're asking me, yes, absolutely.
I'm just asking, what do you think?
Well, there has to be due process. But we want to see those that are abusing the program out of the program. There's no question about that, because it gives our industry, everybody in our industry, a bad name, and it gives the program a bad name. So we do want to see those who are guilty of an offense to be out of the system. But I have to agree that and one of the other things that people didn't understand about the foreign worker program was that the foreign workers coming to this country, the temporary foreign workers, have the same protections under employment standards law in every province of this country, and so they have this. That really hasn't changed. The only thing now is that and we've always said you need to work more cooperatively with the provincial governments, because if there's some employers that are repeatedly guilty of offenses under employment standards, then yes, I think the federal government needs to know about that. So from our perspective, better coordination there is not an issue. But we also have concerns that if some very minor food safety violation or something like that is going to prevent someone from getting a foreign worker, that's of concern to us.
Thank you.
Yes.
I want to be clear about my answer about recourse, because I accept your position too. If an employer is fundamentally abusing their foreign workers, if they're not paying the salary that they told ESDC they would pay, if they're making them work overtime without giving them overtime, if they're not giving them the working conditions that they promised to give them, that's abusive. And that person shouldn't be accessing foreign workers. My concern is when there's isolated breaches that don't meet that standard. The punishment has to fit the crime, and unfortunately the system that they have in place, if there's a breach of condition, it's the same result regardless of whether you do it to 90 employees or 1 employee.
Thank you. Okay, colleagues, I'm going to sum up with some observations, and then I'd like you to stay behind so that we can give some drafting instructions with regard to our meeting next week. So just before I do, I want to say that I think you've been very clear, both of you, with regard to the issues that are of concern to you. Ms. Reynolds, I think we would all heartily support your suggestion that human resource issues within the industry be of the highest possible standards, and probably will go a very long way if the industry itself can regulate those issues to deal with many of the concerns that you and the public have, perhaps from slightly different points of view. And Mr. Maynard, certainly the issues that you've identified in terms of what the regulations look like when if in fact the budget bill passes, are the issues that will determine the extent to which your concerns are well-founded in terms of the breadth at which the issues will apply. And I think there's no question that the hope would be that the way they are interpreted does not unnecessarily harm employment and employers in Canada with regard to the overall issues, but on the other hand, to ensure that those situations which you summarized very well, I thought, in your last comments, are indeed prevented to the highest degree possible. So I want to thank you both for the way you've articulated the issues that you see as concern. I can assure you that we've heard them, and I thank you for that. And with that, I'm suspending the meeting, and I will ask that the room be cleared as the committee goes in camera for a brief session.